say it. SJC-12255, Commonwealth v. Richard D. Jones.
Stolberg, good morning.
Good morning. May it please the court, Nancy Dahlberg on behalf of Richard Jones. This is a case in which the defendant made an adequate showing in support of his Rule 17 motions for production of one of the complainant, KJ's, record of treatment with a psychiatrist and counselors. His showing demonstrated that the records were relevant to KJ's credibility, which was the sole issue at trial, reflecting on her bias towards her father, the defendant, and the household with which he was associated, her ability to perceive and recount, and the effect of the counseling itself on her allegations. Yet the judge refused the defendant's multiple requests for summonses for the records. He held that because no mandated reports were filed, there could have been no relevant statements made to therapists, and that because, at least initially, it appeared that a referral to therapy was made prior to any allegations being made by KJ, they also weren't relevant.
I think he said something else, though, maybe subtly, but I think he said, well, the argument is that what might have been said to a psychotherapist is relevant because someone would be expected in this confidential situation with a non-family member to say something. That was one of the arguments that was made by defense counsel at trial and in the 3 motions under Rule 17. Mm-hmm. And then there was an argument, well, if something happened and she didn't say anything, that would be relevant as it relates to credibility. So we're left with what does Lampron and Dwyer do if there is post-allegation counseling, because the theory would be, well, the records would be available, Lampron Rule 17 would be satisfied because she might have said something, or she might not have said something. So aren't we just back to Stockhammer because you've just, by definition, been able to satisfy it?
Well, I would say no. So in this particular case, the complainant made an allegation to a friend 2 years after the alleged event. About either 2 or 3 months later, she then denied it to her mother and to the excuse me, school adjustment counselor. So whether she made positive statements about something having happened or denied that something had happened, the inconsistency showed that it would have been relevant if she made statements to therapists.
But that assumes, go ahead, finish your thought, please.
And I just want to go back, and since you brought up Stockhammer, and just mention that it was a little head-dizzying to start reading the cases from 1989, which was not that long ago, and get up to today. So a lot of back and forth during a period in which the bedrock, the axiom that Justice Nolan wrote about in Bishop on behalf of the court hasn't changed. It's still a catch-22 if defendants have to know what's in records in order to get record summons into court. And I can certainly read to the court from that language if I have time, but it's probably not necessary. So there are cases not that long ago. There's Pratt and Rathburn that say it was relevant in these cases that the complainant did not make statements while she was in therapy, that she was in a situation where she could have complained and she didn't. So the absence of complaint has been recognized as being relevant all along. And in this particular case, where there were inconsistent statements made by the complainant, that was shown to the judge, that's highly relevant.
Well, wouldn't that apply to almost any situation then, wherever someone has sought some kind of counseling that would come under the rule? And then later, or in the past, has alleged some kind of sexual assault.
Well, it may be, but the court has said that there has to be a showing of some level of relevance.
But
One
wouldn't it be
point-
relevant in all those cases that they never said
That,
anything?
yes, it certainly could be, but the court has said showing of relevance before those are summoned in, and, we can argue the wisdom of that, but right now, that's what the court says. So in a situation where inconsistent statements have been made, as in this case, that should be enough then to summons those in, and is there an absence of statements? In a situation like this, where after the filing of the initial motion, DCF records indicate that the complainant says she had a flashback to the alleged event 2 years later because a classmate touched her leg, that's enough information to have the record summoned in on the issue of her ability to recall, the possibility of her imagination running a little wild here, and accounting for the...
Before you get into, though, I mean, because we're in two different areas right now, before you
Okay.
get into flashback, repressed memory, if we can just pause for a moment, Ms. Dahlberg, on your first issue, there's inconsistent statements, and that would be enough. And maybe it would be enough under Bishop, and certainly it wouldn't have been enough under Fuller. But the issue is, sort of the pink elephant in the room issue is, how many times is there a child rape case where the father is the alleged perpetrator where there hasn't been a recantation? I mean, has there ever been one that you're aware of?
Well, respectfully, Your Honor, that's not a basis for presuming the defendant guilty.
I agree, but what I'm trying to say is, that's not my point at all. My point at all is, where is the barrier of Lampron relevance and the decision to drop down to Dwyer? Dwyer was a drop down on what has to be shown. If you're going to have, well, if he said it, she said it during communications that were confidential, it's relevant. If she didn't say it's relevant. If there was an inconsistency, it's relevant. And if there was a recantation, it's relevant. Then why isn't that just stock hammer in every case? I mean, I'm serious.
Yeah, so to go back just for a minute, in this case, the judge basically said that he wasn't going to provide records unless there was evidence that there were statements about alleged abuse made to therapists. And there's a real paucity of case law post-Dwyer, but the concern arises that the cases that are out there could be read as supporting that decision by the judge, and I would certainly maintain to this court that Dwyer does not require that, does not call for that, and that's far too high a standard. It's almost, I would say, higher than Fuller, because there are no prior cases that I see that say that. Now, to go back, if there is a recantation, and as a trial judge, I understand you may have seen such, that's an inconsistency. And the fact that these are sexual assault cases doesn't mean the defendant doesn't have all of his rights of defense. So if there's an inconsistency, that's a showing of relevance that should require the allowance of a motion for a summons, subject to a highly restrictive protective order that protects the complainant's privacy. When the complainant testifies, he or she is going to be testifying to these highly intimate situations, there's no question. But the existence of one of these statutes cannot trump the defendant's right to a defense, and that's what happens in such a situation. There is no way to attack the credibility of a complainant, which is the defendant's right in every case, without this kind of information, particularly based on this showing. So I understand that one issue, but in this case, we have more than her inconsistencies. We have this statement. And I would say that the flashback, whether it goes to repressed memory or not, I don't think matters. It's a real suggestion that this may have been a function of imagination, of confusion, or it's up to the jury to decide. The defendant has to be able to argue that.
If I can go back to the inconsistency you described, I had thought that when she spoke to the guidance counselor, she said that I dreamed that.
She did.
So she.
And that's what
so
she told her
didn't-
mother.
She didn't deny that she had, I mean, she said it,
She said it didn't happen.
but she went, but she identified that there indeed, she had a dream in which it happened.
The language was, it was just a dream. I don't know.
Okay,
That wasn't
but
explored
basically
further.
She said it was a dream.
It was just a dream. It didn't
Spoke to-
happen,
When she spoke to her mother, did she also characterize it as a dream?
apparently, according to the trial testimony.
So it was, so in both circumstances, she said, I dreamed.
Said
that
the
this was a
same
dream."
thing, yeah. Or she said it was just a dream. She denied that it occurred.
Now, this came out at trial, presumably.
That came out of trial. So in terms of the multiple motions for the records that were made, they were actually made right up until, actually during KJ's testimony. But going into trial, there was the information about inconsistent statements, about the flashback in the 9th grade when someone touched the complainant's leg to this alleged event, and information about significant behavioral problems in the 9th grade experienced by the complainant, including that she hurt a student by punching him, she cut herself, she
Did
was
these come out
cutting
at
herself.
trial? These came out at trial?
This was prior, and there was additional information that I would suggest would only support the need for these records after. But
So
the
jury
judge
knew- the
foreclosed.
jury heard that she'd cut herself, that she had this incident with the boy, or the fellow
No.
student?
The prosecutor was able to get in the cutting, but the judge foreclosed cross-examination of by the defendant. And so he wasn't able to get into this too much. And in fact, I can just, in fact, the judge said in denying this cross-examination,
The short leash comment?
yeah, he was on a short leash, and he said, I've kept you away from any therapy and counseling records, so would leave the inference that KJ had emotional problems that the jury is not going to understand, not hear about. He went on, they're going to wonder whether some of the emotional problems might relate to truthfulness, which I haven't found they do. So he decided that the jury shouldn't hear about her emotional problems, about assault of people on the bus, 2 different students on the bus, about her animosity towards members of her family who ended up actually testifying for the defendant. And that is the second argument that really should lead to a vacating of the
But here's what's going on there, and you know, you, I think, are making the argument well that this evidence might be admissible on the issue of a bias. And it's not clear that that was what happened in cross-examination. But as you know, unlike the Federal Rules of Evidence, we don't have 608B. And a prior bad act suggesting a lack of veracity is not an available means of cross-examination in Massachusetts, with one very, very limited exception in rape and other sexual assault cases under Commonwealth versus Bohannon. So what the judge is doing, I don't think he said it, but what he's doing is he's saying these prior bad acts that suggest a lack of veracity are not admissible under Massachusetts evidence law.
Well, I appreciate you saying, Your Honor, and again, respectfully, I do cite cases on page 45 of the brief, which, when it's a question as to bias, as you've just said, it's well settled that reasonable cross-examination with respect to bias is not discretionary.
If
and that
it's bias, it's not discretionary. If it's
Right.
bias, it's not collateral. Absolutely.
Right. So a witness can be impeached by prior or subsequent bad acts which are relevant to an influence to prevaricate. That's exactly, it was very clear to the judge here that what was going on, and I disagree with the Commonwealth's suggestion that the defense agreed at any point that the theory was unformed or unclear. Her theory was well articulated, but it was dependent on the information that she could A, gather, and B, share with the jury. There was a lot of evidence here that this complainant had reason to either outright lie or that there was some other reason that she was unable to tell the truth.
Or that
I'm sorry,
arguably
Your Honor.
Or that she was telling the truth, but that she was confusing what was a dream with what in fact happened.
Yes, absolutely, Your Honor, thank you.
The testimony of the psychologist on behalf of the Commonwealth.
The social worker,
this-
yeah.
Was a social worker?
Yes.
Did he or she identify characteristics of this victim that were consistent with having been sexually abused?
I won't say she went that far, but what she did was talk about reasons that complainants delay making allegations. In this case, this was a delay of 2 years, that would have resonated very closely with the complainant's testimony for the jury. And to that, in that regard, and it was objected to, and the records were again requested in relation to the defendant's inability, I would say, to make it clear that what that social worker was testifying to could have been the result of other factors.
And the reasons given by the social worker for delay were what?
Well, she talked about accidental disclosure. In this case, it was the complainant's friend who told the school adjustments counselor. She talked about the reasons for recantation that would have been very close to what the defendant said, what the complainant said. She didn't want to, upset the apple cart, it was Christmas, that sort of thing. So in talking about factors for delayed allegations, I would say it would have been very clear who they were talking about.
Okay, thank you.
Thank you so much.
Mr. O'Sullivan, good morning.
Good morning. May it please the court. David O'Sullivan for the Commonwealth. I have with me Kim Fatella, who is the trial prosecutor. Statutory privileges are an expression of the value the legislature places on mental health treatment for its citizens. And that value, of course, extends to the fact that critical to mental health treatment is confidentiality, to the efficacy of that treatment. Now, of course, those values also extend if the receiver of that mental health treatment happens to be, never by their own choice, the victim of a crime. This court's unanimous decision in 2006 in Dwyer, was its effort to balance those important interests against the defendant's interests in presenting in having a fair trial and presenting its defense. And the balance it struck is that it required a showing that the defendant make in the first instance that the particular records they're seeking are evidentiary and relevant, and that is that they must have a rational tendency to prove or disprove an issue in the case, and with respect to its requirement that they be evidentiary, that they're likely to be admissible.
Is it your view, Mr. O'Sullivan, that only two of the prongs of Lampron really matter here? Is it your view that, as it relates to the prong of Rule 17 relevance, that is, and fishing expedition, it can't be for a fishing expedition, is the same standard or a higher standard than for evidence to be relevant for trial?
To be admitted at trial, Dwyer is clear on this, that they are different standards, that there must be a motion and specific findings with regard to whether evidence that may have been ordered subject to a protective order to be reviewed by defense counsel, you need to meet a different standard in order to have that evidence actually admitted at trial.
But when you say a different standard, what do you mean in terms of defining what relevance is in both instances? How do we change? What do the words mean?
Well, the words in Dwyer are, in order to order for a summons, you need it to be evidentiary and relevant, which requires that it have some rational tendency to prove or disprove an issue in the case. For admission at trial, you need to show that it's necessary to a fair trial for the defendant to have this admitted.
So that's where the difference is then, right? In that admission part.
Yes, Your Honor.
But we don't know what these records of Dr. Prince and the Marblehead counseling records say.
Correct.
We can't evaluate whether if it had been furnished to defense counsel, whether it would have been necessary.
Correct. We can never determine that in fairness. What the judge determined, and I would take issue with my sister's characterization of what he found, he did not find that because there were no 51A reports arising from these meetings with Dr. Prince at the Marblehead Counseling Center, that for that reason we know that no statements were made about the abuse. He said that what indications we have from the absence of 51A reports, from the fact that the referral was for something else entirely, that is her behavior at school, that what indications we have are that no statements were made. Of course, we could never show, and I could never represent to the court, that we know for certain what's in those records. But the balance this court struck in Dwyer requires the defendant make that evidentiary showing. And the suggestion that that's an insurmountable standard is counteracted by all the cases in which this court has allowed disclosure of the records. And, they're listed in my brief. I found as many as I could, but they include Lampron, Pelosi, and Lebrod, and other cases.
What do you think about Lebrod? Because that was pretty recent, maybe 2014. And there's a discussion there about the standard, because as Justice Seifert just pointed out, want to try and get into whether evidentiary and relevant and not for the purpose of a fishing expedition is a different standard than relevance at trial. What does Lebrod tell us, if anything, about that?
Well, Lebrod, and thank you, Your Honor, I think this is a really critical point. The court in Lebrod, and it was a rescript opinion, I believe, ruled that in a situation where you had a person who was referred to mental health treatment with a psychologist or psychiatrist for ADHD, in the course of that, that person disclosed and a sexual assault that had happened to her. The psychologist referred her to the DA, and also subsequent to that, the police called the clinician and interviewed him. And it's clear from what the clinician told the police officer that the victim in that case made factual statements, gave a factual recounting, a historical accounting of what she alleged occurred to her. I would submit that wouldn't be the normal case. So we had a clear indication that she had made statements about the abuse, and it appears that this clinician's interview is how they first reacted law enforcement.
Even how it happened, even that she was talked into it, even that level of it.
Apparently, what that case charged, I believe, was rape of a child, so that wasn't particularly exculpatory, and I wouldn't say that that was
No,
the
as to the
reason.
detail.
I'm sorry?
As to the detail.
Right, as to the detail, right. There was a level of detail there about the historical facts of the abuse. That wouldn't be the normal case when a clinician interviews a sexual assault complainant or anyone else. The purpose of a clinician, and the amici make this point very well, I think, in their brief, is not to establish the historical facts. They're not in the role of a criminal investigator for the defense or the prosecution. They're in the role of someone whose job it is to mend the broken psyche. So when they interview the person and when they take notes in response to what that person says, they're doing it in a particular context and for a particular purpose. I wouldn't say that's the normal case, that Lebrod is the normal case. There we had an indication that she gave a historical account of what occurred, and this court found that that was an appropriate reason to disclose those actual records. That's not the normal case. I think you would need to show more, as I think was arguably shown in Lebrod, than the mere fact that they may have discussed it or not. Of course, the legislature in 23320J has created a privilege for rape crisis center records. And that privilege is absolute on the way the legislature has written it. Of course, by the nature of those consultations, we would presume that they've discussed the rape. We would not presume that the judge or the clinician has inquired in a way that, as a criminal investigator would, to establish this historical facts of those cases. And if we have a rule that Lebrod stands for the proposition that the mere fact that it may have been discussed with the clinician is enough, then we would put that whole class of absolutely protected documents, they would, as a matter of course, have to be disclosed. I don't think that's the rule that this court intended. I don't think that's what the facts of Lebrod lead us to, and I think that's an important point.
Does the victim statement that I dreamed it change anything? Raising the concern that her memory is not a true memory, but her memory of a dream.
I would say that, first of all, that was not offered as a reason for disclosure of the records in any of the affidavits or the motions or the oral arguments supporting the Dwyer motions, the fact that she dreamed it. But I would say also that that wouldn't appreciably improve their showing under Dwyer. The fact that she may have given this explanation, of course, the jury heard that, and that was a major feature of the cross-examination.
Right, but does not that open, I mean, you spoke about a broken psyche. Would it not be something that defense counsel could explore to say, when somebody has a broken psyche, that person is more likely to be confused what occurred in a dream versus what occurred in reality? And after all, don't we all sometimes confuse those two, at least for some period of time? Isn't that sort of a problem when you're speaking about a single episode?
Right. Well, I guess 2 points. The first being that we are all broken in some respect.
Yeah,
and
but
it is
not,
a poor view of,
we vary.
right, it is a somewhat benighted view of those who seek out mental health treatment to suggest that they are all fundamentally broken such that
But that's not fair, because she had you kept out a whole lot of other things that suggested that she had all sorts of issues.
Right. Well,
And the jury didn't hear about all those other issues. The jury did not hear the broken psyche part.
Right. Well, what they did hear is they heard on cross-examination and then on redirect examination that she had in fact been prescribed medication, that she'd been prescribed medication for depression, and that she had taken that medication from July of 2008 to mid-October 2008. So to the extent that the jury heard that, so they could infer she met with some clinician, that his or her determination was that this person warrants treatment, including medication for depression. So to the extent that the defense wished to create an inference that merely because the person had seen a clinician or merely because she had depression, she was less worthy of belief, I wouldn't say that's a fair one, but it was there for the jury. And of course, they also heard the fact that she provided explanations to Klein and to her own mother that she had dreamed the abuse. But I would contrast that with a showing like that was made, like that which was made in the Caceres case, where there was a diagnosis in which the person experienced auditory and visual hallucinations and had a real difficulty distinguishing fantasy from reality. I wouldn't say that her explanation to her mom and to Klein in that context is similar to that. That would so improve the showing under Dwyer. But again, they didn't even raise that. Now, with respect to the limitations on cross-examination.
Before you get to that, I'm sorry. We still have to analyze this third request in front of Judge Feely at trial. That's going to be a substantial risk. And there were new grounds.
Correct.
And so that has to be analyzed, including the testimony of the expert, including broader cross-examination on medication as it relates to perception. That's going to be analyzed by us. Before you get to cross-examination, we're going to look at that.
Correct. And with respect to the first issue that Your Honor raised, with respect to the testimony of Leah Gardner Elkin, who was a social worker who testified to disclosures in sexual abuse cases, particularly as regards children, accidental disclosures versus purposeful ones, and recantations, and some of the reasons that might exist for those recantations in that particular context. The defense theory in the Dwyer motion as to those records and the relevance of the MCC and Dr. Prince records, with regard to Elkin, was that the Commonwealth is going to introduce behaviors of the victim in the trial, and they're going to implicitly or explicitly tie those behaviors, that is the acting out in school and thus and such, or we are going to introduce those behaviors, and tie those to the fact that she's been sexually assaulted. Now, the Commonwealth was successful, and I would say, and we'll move on to this issue after, in excluding those as not relevant to bias, as the defendant said, and more closer to 608B evidence. So there was no evidence at trial that the jury could tie specific behaviors to, that they could dovetail with Elkin's testimony. That stuff was excluded. So that testimony, as it shook out at trial, there's certainly not a substantial risk with respect to the denial on that basis. Now, with respect to the limitation on cross-examination, the judge used the phrase, perhaps unfortunate phrase, short leash, but it was a short leash with respect to specific things. With respect to therapy, and which, as I noted in response to Judge Gantz's question, the jury heard that she had seen some sort of clinician, so that was out there. And also with respect to these specific behaviors, this litany of behaviors that the defense alleged showed bias because the victim was seeking and falsely accusing her father of rape of indecent assault and battery to avoid his discipline for these. But as this court has said in Bui and Weichel and in cases since then, yes, bias is generally a matter of right to inquire into, but it's a matter of the court's discretion whether the particular evidence that's proffered actually demonstrates bias. And here, the court noted what I would say was the obvious fact in this case, which is that the way in which KJ's accusation arose, that she first disclosed to Cheyenne, her friend, it would make little sense if she wished to avoid her father's discipline for her to disclose in that way. And what all these misbehaviors had a greater tendency to do is have the jury discount her testimony on a very unfair basis, which is that she's a bad kid. She engages in all this stuff. And as the court points out, we haven't adopted 608B. This is an improper avenue of cross-examination because, for all the policy reasons for our declining to adopt 608B, we don't want to create trials within trials as to whether she in fact punched someone on the bus, her reasons for doing so, whether she lied about her aunt and uncle giving her dirty looks. In a parental abuse case, if the defendant is right about this, about a right to inquire about this stuff, you can imagine them bringing in literally any and all misbehavior on the theory.
But it's fact intensive, and it's a very fragile, difficult line to discern between what's bias and what's prior bad acts suggesting a lack of veracity, which isn't admissible absent Bohannon. And so, the theory is that she doesn't want to get in trouble, and she's arguing with her peers and having these other behavioral issues, and it shows that she has a reason for the disclosure other than its truth. And I think that's what Ms. Dahlberg is saying, is that, just because it isn't admissible under 608B doesn't mean it isn't admissible under bias.
Fair enough, Your Honor. The judge did find it admissible with respect to SJ. Obviously, the way in which her accusation arose made that relevant to bias. She stole $5 from her grandmother's purse. The defendant was informed of that. Discipline from him for that particular act was imminent, and thereby she could sort of bring. I mean, that was the theory as to SJ, and that was well aired. But with respect to and then how does the judge determine? I believe there were 10 or 12 separate misbehaviors. How many of those come in on the theory that the defendant was falsely accused by the victim so that the victim could avoid discipline for those? Where does the judge draw that line? I would say that the judge appropriately drew the line in saying none of these, you've not convincingly shown me that any of these really demonstrate under any reasonable view a bias against the defendant. So for similar reasons that the court said in Bui and Weichel, I would say that the judge was within his discretion in doing so in this case. I see my time's up. If there are no further questions, I'd rely on my brief. Thank you.
Okay, thank you. I will take our morning break.